Hello, good morning, everyone, and welcome to this webinar with the Spain US Chamber of Commerce and with Nelson Mullins, where we will talk a little bit about considerations and plans for reopening your business, which is something that it's going to happen in the next weeks. So it's important for everyone to understand what this reopening is going to imply and what are the steps that we should follow to do it in the right way. So before introducing our speakers today, I just want to remind how it's going to work. So today, our seminar will last around 1 hour, more or less. The presentations will last approximately 35 to 40 minutes, and we will leave the last part for questions. So any one of you that have any question, please send those questions through the dashboard that you have on your right side. On your right side, everyone will see a control panel, and there it's a place where it says questions. So anyone that would like to ask something, you can write it there at any time, and we will gather all the questions and resolve all the answers and give all the answers at the end of the webinar. Well, this morning we have a great team here with us to talk about the considerations and plans for reopening business. So thank you, Nelson Mullins, Roden Castle, for being with us today and share your knowledge. A little bit about the firm, for those of you that doesn't know, Nelson Mullins is a national law firm among the 100 largest law firms in the US. They are members of the Spain US Chamber of Commerce and service clients in the US, Europe, Asia, and Latin America. John Haley is the co-chair of their firm's Latin American practice, and Christine R. and Mitch Boyarsky are senior partners with the labor and employment team. So thank you, all of you, for being with us today, and I hope that it's going to be a very productive webinar for all of us.
Juan Carlos, thank you very much. We very much appreciate this opportunity to present to the members of the Spain US Chamber of Commerce, an organization that we value tremendously and enjoy very much communicating to its members via this new form of communication and networking via the webinars. We're all sort of getting used to this as our new normal. Nelson Mullins, as Juan Carlos mentioned, is one of the 100 largest firms in the country. We have approximately 800 lawyers and government relations advisors. We operate throughout the US with approximately 25 offices, 9 in the state of Florida, from Miami through Tallahassee. We're then going up the eastern seaboard to Atlanta, throughout the Carolinas, Washington, D.C., New York, and Boston, and 2 offices out west in Denver and Los Angeles. I co-chair our firm's Latin American practice group. I'm a corporate finance lawyer and advise clients on a variety of corporate transactions throughout the region. Kristen and Mitch Boyarsky are senior partners of our firm's labor and employment practice. They have been very busy during this COVID, I'll carefully use the word crisis or COVID pandemic. They've been advising many of our clients on labor and employment issues that have come up in response to this crisis, and now sort of a newer chapter that is becoming very timely, which is reopening your business in this new environment. The advice that we're going to be giving, Kristen sits in our West Palm Beach office and Mitch in our New York office, will be broad and really apply to a variety of situations throughout the country. If there's any state-specific issues, they'll highlight that. Again, you have an opportunity to ask us questions at the end. We would encourage you to try and make this as interactive as possible. Thank you again for joining us. Kristen, I'm going to turn the mic over to you. If you could give a brief introduction about yourself, what you've been doing, and then I think the first few slides of this presentation you are the subject matter expert, so please proceed.
Thank you, and thank you, John, and thank you to the US Spain Chamber for allowing us to present considerations for returning to work for employers. As John indicated earlier, Mitch and I have been really busy and our practice group getting plans in place to get you and your business back to work. So with that said, we have come up with a safe office and wellness plan that is something that we're going to introduce to you today. It should be a written plan, and it'll cover a variety of topics, and it's something that we in our practice group have thought about and really gone into some detail. So with that, you'll see on your screen the blueprint to reopen operations. And so an overview of what we're going to be talking about today is the concept of physical operations and access, going to employee screening and testing, cleaning and disinfecting protocols, working conditions, personal protective equipment, and then Mitch is going to continue with employee communications and training, managing employees after leaves of absences and their ongoing requests for leaves of absences, return to work after illness, and wage and hour matters, which are very significant things that we need to consider. So the next slide we'll go to is the initial protocol that you should be considering when you are bringing employees back to work, or if you are reopened, things that you might not have thought of that maybe would be instrumental in making sure that you are open and that you can stay open. Because if something happens and your office space gets reinfected, or a majority of your workforce does get reinfected, it could not only impact the human capital that you have, but the business operations on an ongoing basis. So with that said, the first topic that is to be considered is employee access. So when bringing employees back to work, you want to, in advance, tell them that you have a plan in place and give them some notification and comfort in learning what to expect when they return. Explain to them that the workplace may look different. We will talk about some of the changes that you should make in physical spacing. You should explain that before you're allowed to return to work, you will have to have temperature checks and be screened for conditions or symptoms of COVID. The employer is also allowed to ask specific questions about access, who they've come in contact with, whether they have certain symptoms. You'll need to explain to your returning employees that there will be a protocol for reporting illness prior to the workday, and then during the workday, if you are not feeling well, there will be specific guidelines in place that you will have written. Designated employee and management representatives will understand what will happen if someone does fall ill during the workday, and have everything in place so that when people do return to the workspace, they know that you've thought this through and they can feel comfortable returning to work. You'll also have to discuss and plan visitors and the general public customer access to the workplace, because physical distancing, social distancing, and hygiene are obviously everything that we've heard. Once we have people returning to work, we obviously have to keep them distant, but visitors and the general public, you're going to have to make some decisions about who wears masks, who are you going to let in. Some governmental and local authorities statewide say, I know in Florida, or at least in Palm Beach County, we're at 25% capacity, and that could vary all across the different states and in Latin America as well. And we'd also like you to consider third-party vendor access. Let's say, for example, the person that usually comes to service the coffee machine. You may want to put off having general third-party people unless they do follow the protocol. Just trying to keep your employees safe, keep them productive. Obviously, if you're in retail, you're going to want to have customers. But if you're a general office, and everything is really industry specific, so those considerations we want to make sure you've thought about, have communicated to your employees, And the next slide will talk about the topic of employee screening and testing. So I have here in bold, prompt identification and isolation of potentially infectious individuals is a critical step in protecting workers, customers, visitors, and others at the work site. This is so important to identify and locate people that may be infected. And with that said, you are allowed to take the temperature. You are allowed a certain number of permitted questions that you may ask employees that prior to this may have been considered a prohibited medical examination. With that said, there are confidentiality obligations that the employer has because of privacy laws, HIPAA, and the like. Any sort of testing that you do and reporting and daily logs of an employee's medical condition, it needs to be kept in a separate file, separate and apart from the regular human resources HR employment file. That is a tip that should be made sure. Keep a separate file, separate location. Again, having that designated management employee, whether it's you or your human resource manager or your operations manager, should be knowledgeable about the temperature checks, when they are going to be done, where the screening is going to be done, how you can keep the screening in a separate location before they enter the workplace or a segregated section, understand the symptoms, understand the questions to ask about the symptoms, also asking about possible exposure situations. Some of the remedies we have here is if someone does have that temperature or does respond that they have come into contact with someone who has tested positive for COVID, you can send them home from work. One of the great things about this technology that we do have is that so many parts of our workforce have transitioned very well to working remotely. If that's not possible for a certain employee, say for example, if they are a restaurant server or somebody that is a runner or a delivery person, they can't necessarily work remotely, but most of our workforce has really just stepped up and jumped into technology, jumped into these types of electronic communications policy. Again, if they can work remotely, please allow them to do so, but it's all up to you in your return to work plan. Monitoring temperatures and giving a daily report. Again, I said that it's important to have a log, keep that log separate. Finally, I discussed a little bit earlier about an isolation area. The isolation area is similar to what we discuss in general employment terms about, say, a breastfeeding mother, a nursing room that is kept private and separate from the rest of your general employee population so that the nursing mother has a private space. Look at your business plan, your physical space, and try to find an area that if someone does test positive or isn't feeling well, that person can go and sit. Make sure that there is personal protective equipment, that you help that person find a ride home, identify local treatment facilities, and then obviously continue to report as required by your locality or your specific industry, guidance, or business. Again, can't stress enough that the record keeping should be on any individual employee should be separate. The next screen, we will address sanitation protocols. Very important, and this has to be part of your reopening plan and an ongoing effort by all of your employees to take their desk, their physical space in any areas that they come into contact with, including the restroom, including doorknobs, etc., to make sure that they practice good hygiene, practice social distancing. With respect to cleaning and sanitizing your workplace, the CDC and OSHA standards, and many governmental entities, especially industry-specific entities, have given remarkable direction, and you cannot go wrong if you're following the CDC, the current CDC guidelines or OSHA standards or the slow the spread guidelines with regard to mitigating risk and sanitation protocols. The CDC guidelines gives you a link to the approved EPA cleaning and sanitizing devices. All staff, again, should be trained regarding this new virus about consistently washing their hands, consistently keeping their workstations clean, not sharing devices, or perhaps delegating certain tasks that maybe had been done by a group of people, say opening the mail. Jane will open the mail. With regard to the copy room, John will use the copy room and then spread that out. We want to make sure that people and materials and actual surfaces are kept to a minimum, and make sure that people are not touching the same surface, because that touching and that density and those people are the way that the disease spreads. And so if you can keep your little workforce safe and follow these social distancing protocols, and social distancing is generally considered 6 feet apart, limited use of shared equipment, and a deep cleaning preparation before the entire workforce returns to work. And then again, if an employee does test positive, you're going to want to make sure that you do another deep clean and make sure that the office is safe for everybody to return again. The next slide discusses developing and maintaining a virus avoidant workspace. So when we talk about a virus avoidant workspace, it's something that we can all understand the concept, but only you know your business and only you know your employees and the physical setup of your workspace. Take a look at your space plan. Try to figure out, how can I keep the employees as separate as possible? If they can have separate offices with a closed door, that would be ideal. That's not always possible. How can you keep people socially distanced in an open floor plan? You know, we had a big surge for a long period of time of these open floor plans with desks everywhere, and that was supposed to collaborate and bring people together, and lunchrooms bring people together and have, you know, a unified workforce. For the foreseeable future, we're not going to be able to have those types of things. So look at your infrastructure, look at your ventilation systems, look at your office and desk locations. Another very important thing to consider is staggered schedules or days where appropriate. If at all possible, if you usually have the office come in at 9 to 5, if you could stagger those work schedules by, say, Team A works Monday, Wednesday, and Friday in the office, Tuesday, Thursday remote, switches every other week with Team 2, or have certain people come in at 7:30, some people come in at 8, 8:30, 9. That will eliminate or reduce the amount of people using the common areas, such as an elevator or the staircase, things of that nature. Again, consider allowing continued telecommuting and remote working, depending on what your industry is and the safety interests that are involved with your particular business. Back again to restricting visitors and third-party vendors. The next slide, we will address personal protective equipment. So many of us haven't heard of this PPE unless you're really in the OSHA space or in the medical industry or construction industry. When we talk about personal protective equipment, it's goggles, gloves, face masks, face shields, these N95 respirators. An ordinary employer does not have access to these heavy equipments unless you're in the healthcare industry or otherwise in a compromised situation dealing with infected people. So I want to make clear that face coverings, face masks can be required by an employer. The guidance has demonstrated that and is clear, but a face mask in and of itself is not a PPE. So the general cloth masks that you see people so wonderfully coming together and making, that can be required, and you can require your employees to do that. But I would be hesitant about calling that PPE per se, because it may give a false sense. The PPE is there to protect you from exposing other people to the droplets of the virus, getting on surfaces, or in speaking, coughing, other things of that nature. It's there to protect you, it's there to protect other people, and then it also creates this general sense of safety. It doesn't serve anybody well to argue about who should wear a mask or not wear a mask. If you're an employer and you care about your employees, your customers, you want to have that reputation for being a good community service provider, I would definitely consider requiring everyone to have a face mask. It just creates that environment. It will be a different type of interaction, but we will get used to it in the short term. And for the foreseeable future, it's just something that the government suggests, and we as employment lawyers would suggest that you make sure that at a minimum, they wear some sort of face covering. And with respect to gloves, goggles, and N95 masks, you're really going to have to look to your industry and your specific, whether you're a medical office, what you do, and how close contact you are with COVID infected people to make that determination. But back to the beginning of this, we have thought about all this stuff and do encourage you to create a written plan, make these decisions ahead of time. And the next slide again talks about PPE. No, I think I'm finished with the PPE, and I think Mitch is now going to discuss training. So here we go to Mitch.
Thanks very much, Kristen. I appreciate it and appreciate the opportunity to speak to everyone today. Just one thing to keep in mind, that this is going to be a very fluid process as employers return to work. Just like when the executive orders came out and we got guidance from the government, federal government and state governments on a regular basis. Kristen and I have been in the trenches since then, dealing with and interpreting these for employers or clients. And this will continue. So it's important to really be vigilant, to work with your counsel and to stay abreast of these developments, because unfortunately it's going to be a moving target. On this note, though, I'm going to cover training, and then dealing with employee issues at work, dealing with sickness, returning employees to work, and then some wage hour issues. So first, with regard to training, I feel like training is a critical component, for a number of reasons that I will explain in a minute. But if you think about why you do training with your employees in the workplace regarding harassment, discrimination, and retaliation, there's a few primary reasons. But putting aside those, in addition, now training is going to be essential to help get employees to return to work and feel comfortable. So on the one hand, it's very useful. It will be a process that requires employees to understand what the new system and the protocols will be. But on the back end of it, training will cut down on legal action because it gives you, an employer, an opportunity to deal with a challenge or a problem before it becomes a bigger one. And an employee turns to a third party like a plaintiff's lawyer or a government agency for assistance. So I'm suggesting training for the same reasons that you do workplace harassment training, but with these additional reasons, which is it's going to help get your employees more comfortable returning to the workplace. As Kristen had already described, we are recommending that employers have a written plan like a handbook, which functions as a blueprint to restart operations and to keep them going. Before an employer returns to the workplace, consider informing them about your plan. Provide your written blueprint to them by email or maybe even mail. We call our model policy, the Nelson Mullins policy, a safe operations and wellness plan. After you send the plan to them, to the employees, you should conduct a call or a webinar just like this one to explain how that plan is going to work and what they should expect day one. What will you do before your employees arrive to work? Will they be tested? Will you take their temperature? Will you require them to wear a mask or other PPE? Will you allow them to provide their own mask or a respirator? Well, you need to decide these things in advance. You need to decide whether employees will work a different schedule. Will they work in alternate work days, staggering start times and end times? You would cover all of these things in your training or orientation before you resume operations. So having conducted training will cut down on management time and human resources time to assist employees and to answer their questions to facilitate their return to work. It's also going to reduce their stress levels and your stress level. Even after an employer does training to restart the workplace, I would suggest that you conduct follow-up training or orientation from time to time. As I mentioned, this will be a fluid process where we're going to receive additional guidance from the government and you're going to transcend that to your employees. Next slide, please. So now you have a plan. You conducted an orientation process to give your employees information to facilitate the return. They show up. You've tested them before they start working. You've done social distancing, as Kristen had already summarized, and you've sanitized the workplace. However, an employer reports to human resources or a person who has been dedicated to handle sickness that he or she feels sick. They have a fever, they're coughing, or maybe even they have trouble breathing. So what do? Well, in a direct but calm way, you'll need to move that person to a location that is isolated to protect him or her and to prevent against exposing others. Kristen had mentioned the isolation room. So if you don't have a small room or you don't have the resources to establish an internal facility, what do? You need to think about that ahead of time. You might arrange to exit that employee very quickly, but in that case, you'll also need to decide very quickly whether that person will go home, where that person will go next, and how he or she is getting there. Let's say they drove their car to work. How's that car getting home? Are you going to call a family member to pick him or her up, or are you going to send that person home in a car? So you need to think about what's the next step when the employee does report feeling symptomatic. Let's assume that you do have a room for isolation, again, analogous to a lactation room that you may have used for an employee for lactation purposes. Well, this isolation room will be a dedicated separate area where the employee can go where he and she feels symptomatic of COVID-19. Make sure that that room has a door that closes. You should mark the room with a sign. In the room, you'll have a cabinet or storage area with the PPE. Again, Kristen had mentioned this. You're also going to need an individual, maybe that's a medical professional, but perhaps you don't have medical professionals on staff. So you would need to think about someone who would be assigned to assist an ill employee in the isolation facility, have information available to decide what to do, whether there's local testing locations or the immediate healthcare facilities, and a contact person or contact numbers. Again, think about how that person will be transported and whether that person will need immediate treatment. One important thing, very important to remember, is that you don't want to put an ill employee on public transportation to go home. So depending upon what your resources are, you may want to make some arrangements in advance with a service that can drive an employee who reports feeling sick home. So think about that in advance. And as I mentioned, getting the employee's personal vehicle home or off of your premises. It's possible that you may never use the isolation room, but it will be important to establish this dedicated facility. And it also shows your employees that you're taking the situation very seriously and you're prepared. It is also possible that you may need to communicate with local health officials. Consider having a plan with a communications protocol if an employee is sick. As part of your internal communications plan, you need to think about communications to employees who continue working even after one of their coworkers reports being ill or perhaps diagnosed with COVID-19. That communications can reveal that a person was diagnosed and left, the date that the employee stopped working, if that person was in the office, and assuming, again, making sure that this is accurate, that the employee is self-treating, explain that the employee is self-treating. Kristen had mentioned that there's certain HIPAA and privacy protections applicable to employees, so we have to be careful about the information that we disseminate. If an employee has a more severe case, you'll need to decide how to handle that in terms of the communications, but you would likely consult with counsel for all these considerations, such as how do I manage the leave for the sick employee? What communications do I provide to the colleagues who remain at work? And what will I do to the workplace after we exit that ill colleague, right? You're gonna want to do some deep cleaning and sanitizing. Maybe you're gonna need to shut down the facility and clean it thoroughly for all of those employees who will be reporting to work. Next slide, please. Next, I want to cover leave management for someone who goes out sick. You need to know what leave benefits are applicable for your employees. And this is where you're going to dust off your employee handbook to know what benefits are available. As I mentioned, and Kristen mentioned before, we're suggesting a written plan or blueprint, if you will, that will contain this information. In our sample, we do include a Families First Coronavirus Response Act policy and a leave request form to make it very user-friendly and to explain to employees what their leave benefits are. Just to summarize real quickly, if you have less than 500 employees, and you're not a small business under 50 employees claiming hardship and therefore exempt from the Family First Coronavirus Response Act, then you are required to comply with the Act. So I'm going to focus specifically on the leave provisions of the Family First Act. An employee who is experiencing symptoms of COVID-19 and is seeking a medical diagnosis is entitled to paid sick leave under the Emergency Paid Sick Leave Law. Remember, under the Act, an employee also is entitled to emergency FMLA, and that is for basically taking care of a child who is incapable of attending school or childcare. But we're going to focus now on an employee who is sick. For a full-time employee, the amount of leave is up to 80 hours. For a part-time employee, generally, the leave is a maximum of the amount of emergency paid sick leave equal to the average number of hours that the employee would work over a 2-week period. There are some variations about the amount of leave for part-timers to keep in mind. And again, I would encourage you to speak with counsel for the interpretation and guidance of the Families First Act. Trying to give a little bit of an overview here. In terms of eligibility for leave, there is no minimum required employment for an employee to be eligible for the emergency paid sick leave. The emergency paid sick leave, or EPSL is the acronym we commonly refer to it, is paid at the employee's regular rate of pay, up to $511 per day. The emergency paid sick leave does not count against an employee's vacation policy or PTO accrual, and it doesn't count towards regular Family and Medical Leave Act leave, FMLA leave. If an employee has exhausted their FMLA, assuming you're a covered entity under the FMLA, the employee still could take the emergency paid sick leave. And so if an employee takes time off because of COVID-19 and receives the EPSL, that employee is entitled to reinstatement at the end of the 2-week period. Keep in mind, there are various state laws, so you should make sure you're familiar with the applicable state laws in the locations in which you have operations. States may have paid sick leave laws and other leave benefits. As an example, New York more recently modified its paid sick leave law to allow an employee up to 40 hours of paid sick leave for the employee's own illness related to COVID-19. That is paid at the employee's regular rate of pay, which is not capped at the $511 per day. And there may be other states that provide similar types of leave benefits. Again, those states may have unique provisions for the provision of childcare when schools are closed as well. So you should be familiar with those. I'm not going to cover those in great detail, but when you're putting together your plan, your blueprint, you should consider including provisions about leave benefits and particularly state law. Also, in terms of the Families First policy and you're following it, think about the documentation that you're going to use, because unlike the FMLA, there is no state or federal form that used for permissioning for emergency paid sick leave. We have created our own form. There's no magic to it, but you're entitled to ask questions and obtain information to specify that the employee is taking leave under the Families First Coronavirus Response Act and your policy. I would consider attaching a form to your policy. The DOL has not issued a model form, so you can use some discretion. If you're not covered by the Families First Act, then you need to consider, if you have more than 500 employees, you're providing FMLA, assuming you're covered by the FMLA, and employees can take up to 12 weeks of unpaid leave for FMLA, and they could receive paid sick leave benefits in addition to the FMLA. The FMLA is job protected, so an employee theoretically could take 2 weeks of emergency paid sick leave. If the employee is still sick, the employer would qualify for FMLA, assuming you're covered by the FMLA, and take another 12 weeks, which are unpaid, and that's job protected. Let's say the employee wants to return to work. You have the ability to request documentation. I will get to that momentarily to ensure that the employee is safe to return. In terms of postings and notice obligations, keep in mind that the Department of Labor has posted a notice that you need to put up in the workplace. That's available on the Department of Labor website. Also, you can go on our firm's website. We have a resources page with an abundance of information, including an alert about the policy, the poster that you can easily access and put up. Also, workers' compensation benefits. An employee who contracts COVID-19 at work is covered by workers' comp. Again, keep in mind that some states have issued additional laws and regulations regarding workers' compensation. As an example, California passed an executive order recently that creates a presumption that if an employee contracts or is diagnosed with COVID-19 within 14 days after that employee is at the employer's workplace, workers' compensation would apply. That presumption obviously doesn't apply if the employee has been telecommuting. So lastly, let's remember policies prohibiting against discrimination in the workplace. Those apply as well. To an employee who takes leave under the Families First Act, an employer could not retaliate against an employee who takes leave. An employee could not fire an employee when the employee wants to return from taking leave for COVID-19 purposes. Next slide, please. So I touched on this a little bit before. An employee is sick, then the employee wants to return to work. What kind of documentation can you require? Well, you can ask an employee to state in writing that he or she has recovered from the illness. You might have some options about what types of information to elicit from the employee. As an example, you could ask that the employee confirm whether he or she has tested and now has a negative test result. Number two, the employee has not been symptomatic for 14 days. Or number three, the employee has not been symptomatic for less than 13 days. I would suggest having a form to have an employee fill out, provide the form in advance. Again, something that we attach to our model blueprint and the Families First policy that the employee can submit back to you. Record keeping will be very important for employers to deal with. Obviously, general compliance, but number two, if there is a legal claim made, you're demonstrating that you have done appropriate best practices and preventive measures to safeguard your employees, particularly under the general requirements for OSHA, will go a long way. Now, again, you might have some options when an employer reports that they have recovered from COVID-19. You might have the employee begin telecommuting first. Maybe it's not possible to have the employee telecommute, so you might have to bring that person back more quickly, in which case all of these safeguards about providing PPE and testing and training employees will be even more important. Just to touch on a little bit the federal laws, the EEOC has issued guidance that you can ask an employee whether he or she is symptom-free. You can do that when the employee first reports that they want to come back to work. You can do that when the employee shows up the first day, take the temperature, do testing. Keep in mind that under the Americans with Disabilities Act, an employee still has protections from inquiries about general physical disabilities. So you wouldn't be able to ask an employee whether he or she is predisposed to diabetes or has diabetes or heart disease, but you can ask an employee about whether he or she is symptom-free. And again, the documentation is extremely important. Lastly, I want to touch on wage hour subjects. So if we can go to the next slide, would be great. Reopening may present a significant number of wage hour considerations, both for exempt and for non-exempt employees. For non-exempt employees or hourly employees, they are entitled to pay for time worked, and that includes time that is more than 5 minutes. We call that de minimis time spent preparing for the workday and completing the workday. If a non-exempt employee spends time waiting for his or her temperature to be taken before the start of the shift, that time is compensable if it takes more than 5 minutes. The same answer goes for time spent at work putting on and taking off protective gear. And I'm not talking about, the simple mask or the gloves, but if you require an employee to wear other protective equipment, and the time to, we call it don or doff, to put it on, take it off, and dispose of it, takes more than 5 minutes, that time is compensable. If a non-exempt employee reports symptoms during the workday and is taken to your isolation room, undergoes temperature taking, or is tested, that time would be compensable. What happens if you send an employee who is sick to a testing location off-site? Is that travel time and time away from your facility testing for testing purposes, is that compensable? And again, not getting into too much legal background, but under the Fair Labor Standards Act, there's provisions for what we call preliminary and post-preliminary activity. And under certain circumstances, that may be compensable. So I'm suggesting that employers decide now what those answers will be and have them ready and include those either as part of your blueprint or at your disposal to be able to answer questions if they come up, because they undoubtedly will. Keep in mind that when a non-exempt employee works from home, and maybe has been now, such as when that person is actually working or recuperating or isolating, that employee must keep time records for the time actually worked. And as an employer, you must pay for the time that the employee actually works. If an employee were to claim that he or she has worked overtime or in excess of the regular schedule, there's a presumption by various departments of labor, including the federal DOL, that the time is compensable, even if it wasn't authorized by the employer. So record keeping, again, is really, really important. For all employees, exempt and non-exempt, an employer should decide if they are providing PPE to the employee. We strongly encourage employers, by the way, to provide PPE to all employees. Since this is called, or you'll consider to be company supplies, you should pay for it. But what happens if an employee insists on providing his or her own equipment? Should the employer pay for it? Perhaps you do. If you approve it, you should. Again, the goal is to help employees feel comfortable to resume working, but you also need to be consistent. So I suggest including this information in your blueprint to your employees. COVID-19 may present some additional challenges for employers also with regard to the exempt classifications. Think about an outside sales employee who is classified as exempt based upon the primary duty of that employee regularly making sales away from the office. If that person is now coming to the office every day because he or she cannot travel or go to visit customers, can you still claim the outside sales exemption? That is not something, by the way, that you would state in your written blueprint. However, you need to think about these wage and hour issues before and have a consistent approach for your organization, and possibly separate written guidance for your management, your human resources, perhaps your finance department, on how you're going to deal with some of these exempt issues. Keep in mind, the overtime exemptions could be destroyed based upon pay reductions or modified job duties. So you should know, your state overtime exempt salary thresholds in the event that you decide to reduce wages or reduce scheduling when your operations reopen. We do anticipate a significant number of litigations. Last week when we checked for COVID-19 reported cases, there were about 800 filed more recently. I checked in with the Department of Labor, who reported a few weeks ago that several thousand OSHA complaints were filed. So we anticipate a number of wage hour matters. Having a written plan like our model document or something similar can seriously mitigate against these legal occurrences and your vulnerability to them if you reopen. So with that, we have finished the regular portion of our presentation. I'm going to turn this back over to John to handle questions. Thank you.
Mitch, thank you very much. Kristen R., do you want to maybe come back on us on video as well? That would be great. We have a few questions that have come in from attendees. Please understand some of these questions we may be able to address on this webinar. Some may require further consultation with you. Again, we do need to be careful not to provide specific legal advice on this webinar, but really explain the landscape and regulations that you need to pay attention to. Mitch, I'm going to shift this your way and you decide how we address the question. The question came in: for a small business with 5 to 8 employees in an office setting, what is a typical checklist of things that the employer must take into account and have to put in place? That's a rather broad question. Perhaps we give some generalities of things they should think about.
Yes, thank you. Well, first of all, as part of your checklist, I would consider a list of sanitation and cleaning supplies that you would use. I would try to keep in advance several weeks, perhaps a month's supply, and list that. You should include the rules of engagement for the employees, maybe reference that you have a separate policy or blueprint, as we've been talking, that you will roll out. If there's leave benefits, if you don't have an employee handbook, maybe you're too small, but nevertheless, think about some articulated list of benefits available to the employees. I would think about the rules of the way physically you're going to operate, such as a staggered desk schedule or desk structure. If that's not possible and you have employees working in a very close environment, perhaps consider staggered shifts or rotating work days and include that in your list as well. So if you're going to have an abbreviated list, perhaps a one page, I would consider the very critical components of that. I do think that it's really important to elaborate upon that, perhaps with a more comprehensive document, if you have the resources and the bandwidth to do that as well.
Thank you, Mitch. There's a follow-up question from the same attendee. I may shoot this over to Kristen. Kristen, is it mandatory to do training with our employees in this COVID environment? And what are the minimum requirements for that kind of training?
The interesting thing about this COVID situation is that we get what's called guidance from the CDC, or we get guidance from the EEOC or other OSHA. Training is always in the guidance. So it's a tricky question, is saying, is it mandatory? We will tell you that as employment lawyers, if you came to us, we would say this is mandatory. But is it on the books? Is it a law? Would you get in trouble for not doing it? Certain industries, certainly you would be in trouble. So this training scenario, it's not as difficult as you think. You could do a video and distribute it via email before everybody returns to work. Something similar along lines of what we've done, and talk about, incoming traffic goes this way, outgoing traffic goes this way, and have a written plan. With that said, we've been talking about the safe office and wellness policy, or the blueprint that Nelson Mullins and the thought leaders at the firm across the country have contributed to. We have the blueprint, we have this document, and we'd be more than happy to consult with any business that would be interested to do it. So the burden is not all on you. We've thought about it, we've spent so many hours and so much of our collaborative time and thinking that reach out to us, and we are here as a resource for you. If you feel that you need perhaps a little bit more of a boost or a script for the training, but is it mandatory? Yeah, I'm gonna say yes on that, just based on, I have seen, since businesses have reopened, not had a training policy or protocols in place, and they have gotten shut down again. So if you want your business to open and stay open, follow a policy, do the training.
Excellent. Thank you, Kristen. Next question for either one of you. What about an employee that is sick but told to stay home because they are, that is perhaps not sick, but told to stay home because they are vulnerable and they do not have COVID? What is the employer's responsibility to pay that employee?
Yeah, so I'll respond to that, John. If an employer is requiring an employee to stay home, and this is assuming that the employee cannot work from home, because under the Families First Act, an employee is not qualified for either the emergency FMLA or the paid sick leave if they are actually able to work. But this assumes that the individual cannot work from home and the employer is requiring the employee to self-quarantine. Maybe it's a medical reason or perhaps some other reason. At that point, the time, for the most part, is going to be compensable.
Very good. Thank you. For either one of you, for FFCRA consideration, is the under 500 employee requirement apply for a single physical location or for all company operations combined? Very specific question there, getting in the weeds. Go ahead.
Sure. Kristen, do you want to handle that one?
Well, interestingly enough, the 500 employee is overall, and there are also other corporate structure issues that come into play. So the answer is not as clear as possible, and Mitch might have a different scenario. However, I did see a lawsuit that sued an employer, even though they had more than 500 under the FFCRA, saying that some representative of the employer said, even though we don't have to, we're going to comply with it. So anything's up for fair game on this one. Mitch, if you have a different perspective based on the physical location, you look at your roster and you can base it on employee EIN number, or do you have a different take?
Yeah, so I mean, for the most part, right, and we look at something called the joint employer rules that the Department of Labor regulations and guidance more specifically answers this issue. But if a company has different operating divisions, but is really considered one and the same, again, a very fact-sensitive analysis here, but speaking in generalities, if we're talking about an integrated operation that really has different locations, but is considered to be part of the same employer, then I would say all of those locations are going to be aggregated. Very early on, when the Families First Act just came out, employers were scratching their heads to decide, hey, am I aggregated? Do I include all these separate different operating companies, particularly for private equity firms, or were there subsidiaries under parent company? And I would suggest, you really need to look at the facts there. But when in doubt, I would err on the side of caution in considering nominally separate companies to be part of a single operation and therefore a joint employer, which then you look at the numbers under the Families First Act to see if you are 500 or below.
Thank you, Mitch. I have a follow-up question to an earlier question where I may have misspoke. The situation where the employee is considered vulnerable and told to stay home, that came from the doctor as opposed to the employer. They do not have COVID, but the employee is considered vulnerable The question more specifically is, does the employer have to pay them?
So I'll answer that. As a general response, if the employee is self-quarantined based upon doctor's orders, right? Again, most likely that's going to trigger the protections of the Family First Act, which results in a paid benefit to the employee. If, again, there's different flavors under Families First for what that sick leave or emergency FMLA benefit is. So if the employee is actually sick, it's up to $511 per day. If the employee is not sick and simply self-quarantine as a preventive measure, then that's going to be up to 2/3 of the employee's regular base pay to a maximum of $200 a day. So it may have a difference in the amount of money that employees is paid or eligible to receive under the Families First Act. But I would suggest if an employee, again, assuming the employer is covered by Families First, is self-quarantined at the direction of a treating physician, that's likely going to trigger the protections of the Families First Act.
And in addition to that, I would say that the EEOC has come out with some revised guidance when people talk about being in a vulnerable condition. You also have to then consider whether your requirements to engage in the interactive process with them under the Americans with Disabilities Act. So it's not a one-size-fits-all answer to all of this, because the pay issue is one aspect of it, but you don't want to get tripped up in discussing only pay alone. If there is a disability there that perhaps the ADA covers, you have separate obligations as well. So it's another consideration.
Thank you both. One more question from our attendees. Can the employer lower the salary of the employee and require the same level of workload and responsibilities from that employee, or does that create a legal risk?
To answer that question, so I'll field that, and Kristen can chime in too. But we need to first think about whether that employee is exempt or non-exempt, right? Because for an exempt employee, simply changing the amount of responsibility or time that the individual works doesn't necessarily affect pay. That just might, determine how much effort or output you get from an individual. So if an employer for an exempt employee were to reduce pay commensurate with the reduction in responsibilities or time worked, again, that could be a wage hour issue that could foul up or destroy the exempt classification, depending upon what that reduction in pay is. So that's one thing. For a non-exempt employee, an hourly employee, obviously those individuals are paid for the time that they actually work. So if an employer requires less output for an hourly employee, or reduces the pay rate for that employee, that's permissible as long as they're paid for the time actually worked. And we talked about some of the additional ancillary pay issues for non-exempt employees during the presentation earlier. The pay issue is also a significant subject for any employer that received funding under the Payroll Protection Loan Program, and specifically the loan forgiveness. So that's a whole nother subject, but just keep in mind that if an employer received the PPP money and is taking advantage of the loan forgiveness, again, this assumes that the employer intends to get the loan forgiveness, there are some limitations on the amount that an employee's wages can be reduced without affecting the forgiveness. But as to be more specific, for an employee who is making under $100,000 a year, that reduction cannot be more than 25%. For an employee who's above $100,000 a year, that 25% cap does not apply. So you need to think about if you're getting the loan as well and you're seeking to get the forgiveness. Those are really the two main subjects that I would consider about pay reductions. And then, again, we could spend a whole nother hour in talking about layoffs, furloughs, and pay reductions. But and if anyone has questions, feel free to reach out to us separately. But hopefully that helps answer the question.
Thank you both. Mitch and Kristen, I've asked our host, Juan Carlos, whether we can go a few minutes more with some questions that I have, and he confirmed that we can. So I have a question for Kristen. Kristen, what can an employer do if an employee refuses to come back to work because of fear of contracting the virus?
I think this goes back to the guidance that the EEOC recently revised and came out of, I think it was last week, but it implicates the ADA, and if it's a fear based on it, it's a complicated question, because if the fear is based on an existing protected disability, say anxiety or PTSD or something like that, and I do have some, concern that there's going to be a diagnosis now of COVID PTSD or COVID anxiety disorder that we are going to have to deal with. But it depends on if they're protected under the ADA. It depends on whether or not what their job is, and it depends on the level of fear and the doctor note. Mitch, do you want to speak to that? Everyone's afraid, so we have to treat each situation separately. But Mitch, do you have any other suggestions on? You can't make somebody come.
Yeah.
But
it's a challenge that I anticipate we're going to face a lot. And I already dealt with this earlier this morning with one client. And the general response is that if an employee is just refusing to return, assuming the state executive order allows an employer to reopen, or the employer was already open as an essential business, right? There's a legal basis to stay open or to reopen and to require the employee to report to work. In that case, when an employee just says, I'm afraid, I don't want to come back, keep in mind rules of consistency, right? If you make exceptions to the rules, the exceptions become precedents. So you need to think about this. There is no legal protection merely because an employee is afraid. And an employer could require an employee to return. If the employee refuses, as Kristen suggested before, we can't force employees to act against their will. That person is not returning and may be ineligible for unemployment insurance benefits or any other kind of paid benefits, but that might be the only answer and recourse for that individual. They can apply for unemployment, and it's up to the state to decide whether they get it. If the employee reports that he or she has a disability, then you're engaging in the interactive process under the Americans with Disabilities Act or the state equivalent law to try to accommodate that individual. Kristen gave some good examples, an anxiety or a stress disorder or PTSD. In that case, an employer would need to consider accommodations for that employee. One might be telecommuting. One might be more space in the office to distance employees. Another one might be staggering shifts. I don't think there's a one-size-fits-all solution for that. It requires, again, what we call the interactive process under the Americans with Disabilities Act to try to accommodate. And I would suggest that employers, you get used to this exercise because you're going to repeat it frequently. It already started even before employers have resumed operations. And so you need to think about, am I accommodating this employee? I want to draw an important distinction between FMLA, emergency, paid sick leave, and emergency FMLA, which are job protected, okay? And the ADA, which is not job protected. That's an accommodation that an employer would engage in to try to return the employee back to work, okay? But is not job protection under the Families First Act, under the regular FMLA. So an employer would be obligated to do its best to try to accommodate if possible. If it can, and it's an undue hardship, as an example, an employee is in a manufacturing facility and needs to report to work. Well, you know, there's no remote work capabilities, and provided that the employer does, you know, the things that we have been discussing, orientation and training, having a written policy, communicating that, following it consistently, that will help require or put an employer in a defensible position to require the employee to return to work, as well as to withstand legal challenges. Because yes, you know, training, is it really mandatory? I think in this day and age, if an employer doesn't do it, it's a best practices. Governments, state and federal, are recommending it. An employer would be remiss. And just like we're dealing with in various litigations for harassment and discrimination when an employer refuses to train, it's analogous to negligence. And I could foresee these kinds of creative arguments. Again, Chris and I are on the defense side, but we have to think about what the plaintiff's lawyers are thinking. And I would not be surprised if we see lawsuits claiming OSHA workplace safety violations as well as common law negligence. And what's the significance of that? Well, maybe that's not covered by workers' comp. Maybe that's an end run by the plaintiff's bar, right, to avoid the cap on workers' compensation liability, which is actually an employer's best friend in this situation. So, you know, by not doing these things, you could hurt yourself in a variety of ways, including legally. But by having all of this done, the protocol, the training, the communications, it makes it a lot easier to compel an employer to return, especially if the employer is dealing with a request for an accommodation and has engaged in the interactive process.
Excellent, Mitch. Thank you. Back to you, Mitch. Should I have an employee sign a release or waiver before returning to work?
And this is another question, you know, that Krista and I have been dealing with a lot more recently. Employers are thinking about, well, how do I contract out of liability, right? Can I stick a document in front of my employees that says I can't sue you, or I'm going to hold you harmless for legal claims? And the answer to that is, one, the practical response, which is, do you really want your employees to come back to work? If you stick such a legal document in front of them, how likely is it that they're going to do this voluntarily? But putting that aside, the legal answer, which is those kinds of waivers and releases are for the most part unenforceable and void. An employee cannot waive workers' compensation claims. An employer cannot waive whistleblower retaliation claims under OSHA, at least if it's not a supervised settlement with the Department of Labor. So those documents, for the most part, again, there may be very, very unique circumstances where maybe a company uses that for a third party, a visitor, a vendor, but I would suggest that for an employee, they're not worth the paper that they're written on.
Excellent. Thank you. This is for one or both of you. What record should an employer maintain about taking temperature?
Kristen, you want to handle that?
Sure. It should be a daily log. It should identify the employee by initials or by employee number. Time, date, and temperature log, like the temperature that has been taken. And if anything is over, I believe, 100 degrees, 0.4 Fahrenheit, I don't know what that, the equivalent of Celsius, that would be considered a temperature. Obviously, some people's temperatures run higher than others. You just have to keep that log. And it also depends on if they're working outside, working inside, but the record itself should identify that you have done it for each person that enters the workspace prior to entry.
Kristen, as just kind of a follow-up on that question, if the employer elects to test employees and take their temperature before they come into the office, where do you recommend that be done?
It depends on your specific location, but we would prefer, if you had the space and the capacity, that it be somewhere indoors and a separate cordoned off, maybe by some sort of physical barrier, that the employees line up 6 feet apart and be ready to have their temperature taken, perhaps have some questions asked, and then be permitted to pass through go. So preferably outside of the general population.
We have another question that came in from the audience. Can an employer make employees get tested for COVID-19?
I'll fill that one. So the EEOC has said yes, that testing, although it hasn't said specifically what that permissible testing is permissible. And just to emphasize how the landscape has changed drastically just in the last few weeks that we have been living with COVID-19, the EEOC is very protective and restrictive. And up until COVID-19, for the most part, the EEOC discouraged and in some cases found that kind of testing to be a medical inquiry, which is prohibited, okay, under the Americans with Disabilities Act and maybe even other law. But the EEOC has relaxed that ability for an employer to conduct testing. An employer can take temperature. I think the presumption is based upon the EEOC guidance that an employer could ask for an employee to undergo a virus test as well. But what the employer still cannot do is a medical inquiry about an individual's disability. We covered the ADA issues before in the interactive process. Where your questioning falls or stops is at the point where we're asking whether someone has a predisposed condition that makes them more vulnerable to the disease.
Mitch and Kristen, thank you very much. I know we have a lot more questions we could discuss on this topic. I want to be fair to our attendees and very gracious that they have attended. We've taken an hour of their time and actually gone over by 20 minutes. Want to thank everyone. One little observation I'd like to make to the group is we have been helping clients address these questions in other jurisdictions in Latin America. And please don't hesitate to reach out to us. We have on speed dial subject matter experts in Mexico, Ecuador, Peru, Argentina, Brazil on just these exact similar types of questions in those jurisdictions. And we have been guiding our clients to resolve those matters when they have operations in those jurisdictions. If you have any follow-up questions or more specific questions, there are some email addresses provided at the end of the presentation to Beth Huffman and myself. We would welcome an opportunity to discuss your specific issues with you, and we will bring in Kristen or Mitch or other members of the team as needed. And we'll touch upon after some final words with Juan Carlos on a follow-on webinar that we plan to host in the weeks to come. Juan Carlos, if you want to take it from here.
Yes, well, thank you so much, everyone, for being with us and go through these details on this reopening for the business. So thank you, Mitch, thank you, Christine, and thank you, John, for being with us today. And thank you, everyone, for attending one of our webinars. Please don't forget to check out our following webinars. You can see those on our website. I have just shared our website through the chat. And yes, as John was saying, we are programming another webinar with Nelson Mullins, discussing the lenders and the workout from lends, no, and banks, and how the situation with the COVID-19 is affecting. I don't know, Jon, if you would like to elaborate a little bit more about what we're going to see in that future webinar.
Yeah, so many businesses' credit facilities, whether it's with bondholders, with banks, with private lenders, are going to go into a distress scenario. And what we're going to discuss on the webinar is both from the perspective of borrowers and lenders, of entering into what we call workout solutions, not exercise, but a corporate commercial workout that tries to restructure the transaction so that it can be sustainable for borrowers and lenders going forward without going into litigation, without going into arbitration, and trying to find a practical corporate solution. So the lawyers that would work in that scenario are deal lawyers, they are not litigators. And we find that it's really, frankly, many times in the best interest of the borrowers and the lenders to try and find a commercial practical solution before resorting to the courts or foreclosing on collateral or selling assets in distress, which usually is not a win-win for any side. So we'll be discussing this topic generally. And again, it'll be both for domestic transactions and cross-border transactions. And we welcome the opportunity to discuss that with your members, Juan Carlos.
Thank you. Yes, we'll do that, and we'll keep everyone posted about the date, the exact date, and all the details about these webinars. And as I said before, you can check all the rest of the webinars that we are hosting in our website, SpainUSChamber.com. And also, I would like to remind everyone that this webinar is being recorded, so we will share with you this video, and also we will share the contact information from Nelson Mullins. So if anyone would have any additional question, you could address that question directly to them. Again, thank you, everyone, and stay safe and sound for the next webinar. Thank you so much. Goodbye.
Thank you.
Everyone,
Thank
bye-bye.
you. Bye.